The Honourable Adam Searle.
Mr Deputy President, I lead for the Labor opposition on the Industrial Relations Amendment Industrial Court Bill 2016. I can say at the outset that the Labor opposition will be opposing the legislation. We don't think it is a reasonable or necessary measure. And I know you'll be shocked by this revelation.
Order. Order.
The legislation before the House seeks to abolish the Industrial Court, also referred in the legislation as the Industrial Relations Commission in Court Session. As an ancillary to the abolition of the court, it will transfer the remaining judicial member, the current President of the Industrial Relations Commission and of the court, Justice Michael Walton, to the Supreme Court. That is not only a necessary outcome because the Industrial Court is a superior court of record, and because of holding a judicial office of that kind, the government would be required by the Constitution to appoint Justice Walton to an equivalent court, and of course the Industrial Court is equivalent to the Supreme Court of New South Wales. It also makes a number of ancillary changes to the operation of the Industrial Relations Commission as a tribunal. The office of President is abolished, and the lesser position of Chief Commissioner, said to be modelled on the West Australian approach, is to replace the office of President. And although the holder of that office will be required to be a Australian legal practitioner, they will not be a judicial officer.
Yeah, thanks.
The office of Vice President of the Industrial Relations Commission, which has been vacant since Justice Walton became President of the Industrial Relations Commission on the 3rd of February 2014, that office hasn't been filled and it will be abolished. The functions of the Industrial Court will principally be transferred to the Supreme Court and in some limited cases to the District Court, and some minor functions will be retained by the Industrial Relations Commission. One of the things that members of the House may not fully appreciate is that although the Industrial Court is equivalent to the Supreme Court, it has tended to operate in a much less formal and legalistic way as compared to a mainstream court. And in particular, the kinds of parties that approach the Industrial Court, registered industrial organisations, individual applicants, sometimes represented, sometimes not. The prospect of approaching the Supreme Court is a much more daunting prospect, and I think will act as a disincentive to many people seeking redress. For example, a substantial part of the remaining jurisdiction of the Industrial Court is breaches of industrial instruments and the recovery of outstanding wages. The Industrial Commission and Court has, in various iterations over the last 100 plus years, played a significant role protecting and supporting working people in a less formal, less legalistic way. These changes will end that, and just to give, and so not only does that expose litigants to the higher costs of approaching the Supreme Court, although it is the case that the Industrial Court has the same costs jurisdiction as the Supreme Court, it has tended not to work in that way. And that is for this reason. Judges of the Industrial Court are also deputy presidents of the Industrial Relations Commission, and they are able to switch between exercising judicial functions and non-judicial functions as needed, often in the same proceeding and in the same courtroom. So, for example, if you have a situation where a protracted matter hasn't been able to be resolved before litigation commences, as the evidence is being taken by the court, the attitude of the parties changes. Now, of course, there's nothing to stop parties reaching an out-of-court settlement even in the middle of a trial, but sometimes parties can't do that. They don't have the skills. They need a third party, an independent umpire, if you will. And sometimes, because of the nature of the litigants, they need a circuit breaker to provide them with the opportunity of being able to reassess their position. In an industrial court proceeding, the judge can become an arbitrator or a conciliator at will, as the parties need. There is no need to delay or waste court time. The matter can occur straight away. Under the model being proposed in this bill, if the parties wish to go to conciliation mid-trial, they'll need to ask the judge to stop. They'll need to ask the judge to exercise potentially the functions in the bill under the new proposed section 109, which may not work because, as I read that current provision, it seems to provide for the Supreme Court to refer a matter to conciliation pre-litigation. So it's unclear to me, at least, whether that provision would operate to enable a non-litigious outcome once litigation has been commenced. And so the current arrangement, which I'm sure wasn't intended, will lock parties into high-cost litigation once the court processes have been invoked, unless they can resolve matters themselves. So, on one view, this bill is a small step, but in another real sense, it is a very significant change. It is the latest attack, if you like, in this government's war on working people and the institutions created to support and protect working people. Since this government took office, there have been a range of measures which have attacked the independent umpire, the Industrial Relations Commission, stripping it or narrowing its jurisdiction or limiting the space within which the tribunal can operate independently of government. And in relation to, and in that situation, what we have seen is that the government often invokes the diminution of the Industrial Relations Commission's workload as a reason for the diminishment of the tribunal. But what you can see from successive annual reports is that although the jurisdiction has contracted, first of all as a result of the Howard government's work choices laws, and then because of the way in which the Fair Work Act was constructed and the migration of private sector employment matters to the federal system, yes, there has been a contraction of work in the state commission, but nevertheless there has been a sustained high level of work, and retirements amongst the commissioners, which were largely until recent years not replaced, did lead the tribunal to drowning in work. And I must commend the efforts of the current President, Michael Walton, and the commissioners that have worked with him in doing their level best to stay on top of the work of the tribunal. And so, despite the change in the nature of the jurisdiction, there has been a significant workload still imposed on the Commission, and that needs to be recognised in a way that is not addressed in this bill. But the workload of the court has also diminished, not as a result of work choices or the Fair Work Act, but largely because of the actions of this Parliament in stripping the industrial court of its jurisdiction to deal with work safety matters. In 2011, this Parliament, at the urging of the government, made significant changes to work health and safety legislation, which essentially created three categories of offence. Category 1, the most serious offences, were to have jurisdiction conferred, as it were, on the Supreme Court. Category 2, the next most serious, were to be given not to the industrial court, the traditional repository of this jurisdiction, but to the district court, a court without specialist expertise or training in this field. And I must say, when the workload was given to the district court, there was no additional training or additional judicial appointments given to that court to enable it to stay on top of the work. And it has simply added to the stress and workload of that important court in our legal system. Category 3 offences, the least serious, were left in the industrial court. So we have this anomaly of a Superior Court of Record equivalent to the Supreme Court being left with a very residual jurisdiction in this field. And so, for example, when you look at the annual reports, in 2011 you can see that of the 219 matters filed in the industrial court, 144 were work safety prosecutions. Of the 244 matters completed by that court, 160 were work health and safety matters. When you get to 2012, after the work safety laws went through, only 6 new prosecutions were commenced in the industrial court. 107 of 180 of the matters disposed of by the industrial court were work safety prosecutions. When you go to 2013, there were no matters filed in the industrial court in the area of work safety prosecutions, and 70 of 148 court matters were work safety matters. And then you come to 2014, which is the most recent annual report, and we can see that, again, no new prosecutions were filed in the industrial court, and 16 of the 91 matters disposed of that year by the court were work safety matters. So you can see the diminishment of the workload of the court is attributable almost directly to the stripping of that court of its jurisdiction. Now, to place all of this into some context, for over 100 years there has been a commission, a tribunal and a court that has served working people and industrial parties and the wider community well on a more or less bipartisan basis until fairly recent times. In the 1990s we saw the creeping in of the ideological war in industrial relations. There was the Nyland Green Paper that proposed what were then fairly radical changes to the New South Wales industrial relations system, and John Favour, then Minister, implemented piecemeal fashion significant changes to the industrial relations system. One of the most fundamental changes was the extraction from the IRC of the judicial functions. And so the Liberal National Government of 1988 to 1995 actually created a standalone industrial court as a superior court of record. As a standalone, it was, but it was the urgings of the Liberal National Coalition, and of course kept a separate industrial tribunal, largely populated by the same people. The judges of the court were the judicial members of the tribunal. And it was the Labor government of 1995 in which I worked as a staffer for the Honourable Jeff Searle, who was the attorney and the minister responsible for the 96 legislation. It was a long time ago. I disclosed the interest.
Oh, yeah.
The fact is that the two functions were combined. So we have an integrated court and commission where the needs of justice, the flexible approach given by this sort of approach, is able to meet the needs of the situation in a way that is not as formal or legalistic as traditional black letter law litigation. And that is a model which we think has worked well and should continue to work well, notwithstanding the diminution or contraction. And of course it must be recognised that, again, the justification for this latest change is, well, look, there's only one judge, there's not really enough work for a separate court. But the fact is, the people that work in the Commission and the Registry will continue to do so even after the judicial functions have been taken to the Supreme Court. The one judge will be a judge of the Supreme Court. In fact, this move will actually cost the taxpayers money because the government will be appointing a new Chief Commissioner, presumably remunerated at a level higher than your traditional Commissioner. And so this will be a net additional cost. Not a big one, I grant you, but there is no cost saving. So there is really no significant rationale behind this move other than a continued diminution of this specialist jurisdiction dedicated to working life and working people. Now, for those of us on this side, we think this is contrary to the view we have historically taken, including since going into opposition over the last 5 years. We have consistently opposed the many changes that have seen the role and scope of the industrial jurisdiction reduced in this state, and at each opportunity, whether it's debates on the work safety legislation, or, for example, about the construction of NCAT and what jurisdiction it should have, we have continuously argued that there should be a single court and tribunal that deals with the world of work. We say, we believe, and we know that there is significant, more than enough work existing under state laws, given to different courts and tribunals that would keep a fully functioning court and commission more than fully engaged. It's simply where governments and parliaments choose to allocate that work. And we say, for reasons of specialism, expertise and providing a proper level of service, public service to the wider community, that all of this should be proposed in an enhanced industrial relations commission and court. And we argued for that, not only in this place, in adjournment speeches, in debates on various bills and in other forums, but we took a platform of this nature to the election in 2015. For Labor, the world of work and its impact on the individual, the family and the wider community are central to the way we see the world, and it informs our actions in the Parliament. We believe we live in a society, not merely an economy. There are workplaces but there isn't a labour market. People are not merely units of production, but individuals with families and lives outside the workplace, which is why we continue to support fair shop trading laws, including existing protections for Good Friday, Easter Sunday, Christmas, Boxing Day and Anzac Day morning, which is why we resisted the changes made by this Parliament last year. The evidence shows that removing these protections will not increase employment or economic well-being, but will only reduce the quality of life for affected workers and small business operators who are forced or pressured to work these days. We not only want a healthy economy to grow jobs, but we want those jobs to be of good quality and to provide meaningful work for those who need it. This is a key measure, we think, of social as well as economic inclusion in society. And an integral part of this is ensuring that all people are treated with dignity at work. Properly functioning institutions such as the Industrial Relations Commission and the Industrial Court support this, we think, are vital to the public good. While the new industrial relations landscape has seen the private sector workforce move to the federal system, there remains important protections that the New South Wales system can and should provide the whole community, particularly where federal law is inadequate or absent. Labor's industrial relations laws that we've argued for would focus on ensuring that all working people in New South Wales should enjoy rights to a safe workplace free of bullying and all forms of discrimination. And we think that there should be a single, properly resourced, independent umpire to properly deal with all matters involving the world of work that currently arise under state law. And this is not a new proposition, something we've consistently argued for. We think the Industrial Relations Commission and Court should be given the widest possible scope for protecting working conditions that are possible under state law. And of course, the New South Wales IRC has been at the centre of ongoing innovation for the workforce. Not only the public sector workforce, but for the private sector workforce. I mean, what people now enjoy, for the most part, for example, in the National Employment Standards, in terms of their rights to redundancy, actually started as test cases in the New South Wales Industrial Commission in the early 1980s during the recession, because people ran out of work with no financial cushion to soften the impact. It was the New South Wales IRC that really embraced the notion of redundancy pay, initially in awards, but more generally, and then that idea migrated into the federal system again by the mid-1980s. And the approach being taken by the current government really would seek to prevent that kind of innovation in terms of occurring in the future. Under the coalition government, the enforcement and prosecution of work safety laws has been significantly scaled back. Trade unions have largely lost the ability to enforce those laws except in extreme circumstances, and the rates of accident, including fatalities, we think remain unacceptably high. The 2012 workers' comp changes reduced benefits to injured workers to the lowest level of living memory. And of course, amongst the harshest changes are the time limits on medical treatment, the removal of coverage when travelling to and from work, and the retrospective removal of rights from workers injured many years before the changes were implemented. Now, while there has been some more recent winding backs of those laws, it's very little. So we think that there need to be mechanisms so that workers and unions can more effectively enforce work safety laws outside criminal prosecutions, including obligations on employers regarding rehabilitation and return to work, including ensuring that any disputes about treatment or compensation are resolved by an independent tribunal, and returning all work safety prosecutions, well, we think, to the industrial court, but if it's not to be in an industrial court, it should certainly be in a superior court of record. So that is the context in which we approach this bill. We think is just a continued attack on the jurisdiction that has protected working people. Even when you look at the idea, well, if you are to abolish the court, it's a sensible thing to transfer all of those functions to the next most like court, the Supreme Court, and I can see at one level the sort of the superficial appeal of that. But again, when you look at the nature of the litigants, individual workers, often not well remunerated, industrial organisations, both unions and employer associations, the sort of strict black letter approach of the Supreme Court is probably not the most appropriate forum. So, for example, if you take breaches of industrial instruments and the recovery of wages, we think that should be left in the Industrial Relations Commission, although dealt with by tribunal members who are legally qualified. It doesn't need to be in a court. Similarly, laws to do with the regulation, registration and deregistration of industrial organisations, that should also be left to the tribunal. And for example, the Commission at the moment can make dispute orders in the settling of industrial disputes, and where those dispute orders are breached, traditionally those matters have been heard in the industrial court. And the reason for that is because they are serious matters, but again, the judges are not just black-letter law judges, they're judges drawn from a background and a specialty where they understand the industrial landscape and the nature of workplaces, and can and that background and experience can inform their decision making. Simply passing that function of enforcing dispute orders to the Supreme Court, there's no guarantee that any of the judges who do have an industrial relations or workplace background, of whom there are a number on the Supreme Court, would necessarily be the ones who would deal with these matters. And so there is again a risk of judges taking I don't mean this unkindly, but a different legal perspective and tradition to these matters could lead to harsh outcomes, outcomes that are not warranted in the circumstances. And so we think that there are functions of a court that should be left in the Industrial Relations Commission. Similarly, there are approaches taken in the industrial jurisdiction which we think should follow any work that goes to the Supreme Court. So, for example, and this is embraced in part by the bill, but not fully. So, for example, there is a provision, Section 166 of the IR Act, which provides that non-lawyers can represent parties to proceedings. In the case of unions, their officers, and that parties can appoint agents. Now, the bill before the House enables the Supreme Court to allow that to happen, but there's no right for it to happen. We think that process should follow the work, as it were. Equally, while the Industrial Court is the Superior Court of Record and has the same costs powers as the Supreme Court, those functions are very differently applied, particularly where the parties are industrial parties. And so we think that the current costs approach that constrains the Industrial Relations Commission and embodied in Section 181 should again follow any work transferred from the Industrial Court to the Supreme Court. And we have a series of amendments that seek to achieve that outcome. As we say, we think the abolishment of the Office of President is, an effort to further downgrade the seriousness and importance of the tribunal. We seek to resist that. The other thing, though, which I touched on earlier in my contribution, is about the workload of the tribunal and the resources that it has been given. And it's simply a case, when you look at the annual reports, you will see that despite the contraction of the jurisdiction, retirements, non-replacement of members has led to the tribunal struggling for a number of years to stay on top of its work, which it has done in a very cost-effective way and in a way that has met the needs of parties, but it has become increasingly harder to do so. And the government, despite repeated promises, was very slow to make new appointments. But I do recognise in the last couple of years the appointment of Peter Newell as a commissioner, and also John Murphy, both former barristers. And I acknowledge that Commissioner Murphy was my former tutor when I came to the bar. And they're both very well respected members of the industrial community, and they're doing a very good job. But again, those two appointments have not proven to be sufficient to keep on top of the work of the Commission. And the government, in its targeted consultation about this bill, I'll come back to that in a minute, has said that there are currently 5 members of the tribunal, and it's in their intention to keep 5 members of the tribunal in place. And that's fine, but of course, apart from needing to appoint a chief commissioner, there is at least one commissioner of the tribunal who will be retiring in the near future. And I'm sure the government, well, I asked the government to give a commitment that they will honour what was said in the brief to stakeholders. They will keep at least 5 full-time equivalent members of the Commission in place. But we think it should go beyond the commitment given by the government verbally or in writing. We think that there is no diminution of the workload of the Commission in sight, and we think there should be a legislative guarantee that there will be at least 5 full-time equivalent tribunal members. That probably still won't be enough to ensure the Commission keeps on top of its work. And in relation to police appeals, or appeals involving proceedings under the Police Act. The government has, of course, acknowledged this. If you look at clause, or Schedule 2, clause 2.30 in the bill, that deals with proceedings under the Police Act and appeals. And there is a problem with only 5 tribunal members in constituting a full bench of 3 members to hear appeals from any one member. It's just an obvious mathematical question. If you've only got 5, you know, what if they've all got appeals against their decisions? Where do you get full benches from? In police matters, this has been quite acute in recent years. In the government's exposure draft of the bill, the provided a very inelegant proposal whereby the Chief Commissioner could, as it were, appoint temporary commissioners to make up a full bench. Now, the problems with that are manifest. You'd have a situation where the head of the jurisdiction was hand-picking his or her co-workers who, although I'm sure would take their oath of office very seriously, there would be a perceived lack of independence in those decisions. The government's replaced that in clause 2.30 with this equally inelegant mechanism whereby if the Chief Commissioner feels there is a need to do so and the Chief Magistrate agrees, a magistrate can be co-opted to act as a member of the Industrial Relations Commission. Well, that's inelegant and I don't think very good, but at least it provides the resources for the tribunal in police matters. Police 181D matters where a police officer is removed from the police force, or disciplinary matters under 173 and the like. But what about non-police matters? Unfair dismissals, industrial disputes, award matters in the rare cases where there are appeals from a single bench. There is going to be a very significant and acute problem with resourcing full benches under the model being proposed by this government. And I think that is a shame, and that is something the government needs to address. So, as I acknowledged at the outset, the Labor opposition has consistently taken the view of, if you like, rebuilding and enlarging the jurisdiction of the IRC and the Industrial Court, and we think that is the sound and appropriate course of action for public policy reasons. And so for those reasons we will be opposing the second reading of this legislation. However, should the legislation survive the second reading vote and we move into committee, the concerns and shortcomings of the legislation that I have endeavoured to outline are addressed in our 50 amendments which have been lodged with the clerks. But although that is a reasonably high number of amendments, they essentially fall into, if you like, 2 categories. One is relating to the jurisdiction and membership of the Industrial Relations Commission, the chief amendment of which is number 7, as well as number 6, and there are a series of supplementary and ancillary amendments that largely reflect that. There is also a series of amendments that deal with industrial proceedings in the Supreme Court and the processes that should govern that, which I have outlined in my second reading contribution. And that also touches on work health and safety matters, where we think that if the Industrial Court is to be abolished rather than, as we would prefer, rebuilt, we think that all work safety matters should be in the Superior Court. And it's for this reason, and it's not simply a punitive reason, but it's an important reason. When you look at judgments of the District Court judges dealing with work safety matters, you can see a very clear trend to significantly lower penalties in terms of matters where there are workplace injuries and fatalities. The Industrial Court set very high, very stringent standards for work safety in this state, and there was a very high level of prosecutions in years gone by. This government has run down the number of prosecutions, but equally, even those that have been brought in the District Court have led to significantly lower penalties. And we think, and we don't take this view for punitive reasons, we think that is bad public policy. because it says to the unscrupulous employers who are feeling financial pressure to cut corners to get quicker, cheaper outcomes, it perhaps unwittingly suggests that they can do that and get away with it. One, because they're relatively unlikely to be prosecuted, because this government has significantly wound down and back the number of OH&S prosecutions that are brought by the prosecutor, and unions are no longer really able to do that. But secondly, because where prosecutions are brought, because there are likely to be much lower levels of penalties imposed by the court, the risks of breaking the law are significantly diminished. And when this Parliament debated the work, health and safety laws of 2011 and again in 2012, and I think even in 2013, where there was a need to patch up the legislation due to poor drafting in 2011, I said, and I wasn't the only person in this place, that the risk of transferring these functions to the district court without adequate resources, without making sure the court was properly trained to deal with this jurisdiction, would be lower penalties, lower outcomes and lower work health and safety standards in our workplaces. Less safe workplaces meaning more injuries, more fatalities. And sadly we think that has proven to be the case. And so we have a series of amendments to say, well, if you're not going to have an industrial court that deals with these matters, all of these prosecutions, except the least serious ones, should be in the Supreme Court. We have left open the possibility in our amendments that less serious matters should, of course, be brought in the local court, and that facility will still be available for a prosecutor. In conclusion, I would like to acknowledge the significant contribution made to the Industrial Relations Commission, to the Industrial Court, to industrial law and practice, and indeed social outcomes in this state of Justice Michael Walton. Justice Walton was a leading industrial barrister before being appointed Vice President of the Industrial Relations Commission and Court on the 18th of December 1998, and led many full benches setting important industrial standards and test cases, and of course as a judge heard many leading and important decisions, including being the judge of first instance in the Kirk matter, which went to the High Court and which saw a significant change to law and practice in the industrial jurisdiction, wrongly we think, at least the Labor opposition thinks. Since 3 February 2014, Justice Walton was appointed as President of the Industrial Relations Commission and Court, and has, with diminishing resources, ensured that the Court and the Commission has properly and effectively acquitted itself in terms of its role and jurisdiction. And of course, being the head of jurisdiction of a Superior Court of Record, Justice Walton has also been a member of the Judicial Commission of New South Wales and has been active in the Australian Institute of Judicial Administration with some distinction. And our opposition to this legislation before the House is in no way a reflection on him or his record. And indeed, if the court is to be abolished, it is appropriate that he be transferred to the Supreme Court. It's just that we take the view that the court ought not be abolished. It ought to be rebuilt using laws and processes that are already reposed in different courts and tribunals in this state. But should be focused, all workplace matters should be focused in a single court and tribunal. We would ask honourable members in this place not to participate in the continued dismantling of this specialist jurisdiction, but to call a halt to that process so that the government can rethink its approach and perhaps hear the needs of working people and take the view that, yes, there are plenty of processes under state laws that really should be made more accessible to those who need it in a single tribunal focused on the workplace. Thank you, Mr. Deputy President.